Judge, to just kind of, we cobbled our brief together pretty quickly, but I think I'm in favor in Guzman, you can't put a witness in front of the jury just for the purpose of having him invoke. Both courts used a hearing outside the presence for that threshold determination. Past that, Judge, I don't really know what their intentions are vis-a-vis what they say wouldn't be covered. However, to the extent the entire exercise is so they can try and put impeachment evidence in front of the invoking witness, we cited Jackson versus State in 498 7 2nd 906, Hernandez versus State at 31 7 2nd 873 or 7 3rd 873, and Ruff versus State at 31 7 3rd 833. All of which stands for the proposition that you can't try and use the calling of a witness as subterfuge to put a document which is otherwise inadmissible in front of a jury. What happens, Judge, as we see it, is, again, subject to your threshold determination of the invocation, which we don't think, and this is where I was a little confused at the bench earlier, we don't think there's any question under favor in Guzman that inquiry has to be done in front of the jury. You don't go through this legal process in front of the jury. I don't know what they say they're going to put past that, but what happens to the declarant as to those issues as he becomes unavailable for purposes of 804, which at that point makes the deposition admissible for whatever purposes, and we go from there. I guess all of this is subject to their being Gawker's bigger point, that they think there are things outside of the areas in which the witness would invoke, which we have to go through that process with Mr. O'Brien, I think, anyway. So,
do you think that they're looking at the distinction between the criminal and civil realm? And the criminal realm, or in the criminal case, he pleads the fifth, and that's basically it for testimony, right?
Most of the criminal cases have more of your blanket assertion type situations, yeah.
In a civil case...
But if I could, just one qualifier there, Judge, that's not, to me, particular... That could apply civilly. That's just how those cases seem to be factually, because there's usually just one issue. But go ahead.
It seems that in a civil context, that's not necessarily so.
No, that's... The Guzman case is civil. And Guzman was a third-party witness, I believe, and as the court went through this process, they cited Favor, which is a criminal case, and essentially used the same standard. It had note 7, really the applicable language, in which the court stated that the trial court permitted appellee over appellant's objection to call Christopher Broderick to the stand after appellee had informed the court the witness had indicated he would not testify. Once called, Broderick was asked by appellee if he had stolen the DC-4 aircraft from Gawker's premises. As expected, he invoked the Fifth Amendment. Appellee's counsel then indicated he had no further questions. Appellants contended it was error to call Broderick to the stand for the sole purpose of having him claim his Fifth Amendment privilege. We agree. That's a civil case.
That's the sole purpose, where there may be other purposes.
Well, and I think that's why I kept saying when we were up at sidebar before, and then, of course, Judge, without reading all the language, of course, the danger of it is this. Neither party gets a right to any inference. And so you put a witness up there, and it just confuses the jury as to what the invocation does. So that takes, to me, the Fifth Amendment stuff out of play. That's why I kept referring to earlier the idea that once you make that threshold determination, that is, he doesn't invoke in front of the jury, if they have other reasons for which they want to call him, and they want to be candid about that, then I can respond as it relates to whether they're falling into those setting up their own impeachment cases, and it's just a subterfuge to try and get statements which may otherwise be hearsay in as impeachment. The other question becomes, Judge, at that point on rebuttal, because the declarant becomes unavailable at that point, whether we put his deposition on as an 804 declarant unavailable deposition in rebuttal. All of it springs off that initial issue, and so I think we need to hear from Gawker as to what they think is outside the Fifth Amendment realm, or from Mr. O'Brien, because he's really the one who's invoked.
And Mr. O'Brien's here. Mr. O'Brien stated opened his mouth to this case.
But I think that the simple premise of that, Judge, is, and I think Mr. O'Brien made it clear earlier, he tried to ask the defense what they were going to get into so he could make a decision as to whether they would invoke. At some point, they have to talk about that.
But in all the cases, it says on a case by drawing of adverse inferences should be considered on a case-by-case basis. And it's all basically goes to trustworthiness and social truth.
And you get into issues like control, and if you're talking about Gawker factors and all that. Now, again, I don't think Florida, because that's an 11th Circuit case, the Florida cases, Guzman in particular, make it very clear it's reversible error to just let him go on the stand and invoke as to the areas that the court determines he can properly invoke. I don't think that what the defense is saying is that we're going to do that and ask him in those areas which the court identified earlier that may relate to, some of the bigger issues in the case, that we can make him do that. I think that Guzman makes that pretty clear as reversible error to do it. The question then becomes, what else do they want to call him for? Can he invoke or will he invoke? And regardless of whether Mr. O'Brien knows a lot about this case, I think it's certainly his client's right to invoke where he sees fit. That's his call. It's his right. So we kind of do have to hear from him on that. Then, Judge, we have that sort of final argument, which is this just a subterfuge? Are they trying to figure out a way to get some paper in that they can't get in without trying to do this? So that's how I kind of see the issues bigger picture.
So how, if we don't proffer outside the jury, how do I know, as the one that seems to have the discretion to make that decision, whether it is duplicative, the testimony is duplicative, harmless, or trustworthy, or as far as or something that's totally outside the realm of his assertion of
That's a good question, Your Honor, and I think Mr. Turkel talked about a number of different things. I think your question touches on several.
My question really goes pretty much to the Gawker Investments case.
And that's where I was going to go. I mean, the way that I understand the state of the law is Guzman was decided in 1982 and was based on then existing federal law. In the intervening 24 years, there's been an evolution of Florida law, or there's been an evolution of federal law that has addressed the context of a non-party witness invoking the Fifth, and at what point can a party call that non-party witness to the stand. And this takes us to the case that Mr. Turkel mentioned that I think Your Honor was alluding to, the Gawker case from the 11th Circuit in 2014. And in that case, the court talks about 4 factors to look at and says that you can call a non-party witness to come to the stand, to invoke the privilege. And then it goes even further and says that there can be an adverse party drawn against one of the parties by that witness's invocation of the Fifth. And there's 4 factors that the court said that you look at, and I think that this is now accepted federal law. First, the nature of the relationship between the witness and the party.
Second, and I get that part, and I understand your argument on your minimum set that out very clearly. Here's I guess my question. Then you get down to if you look at the clean. Well, it's contained in on page 13 of that, right above it's 11 and 12. Here it goes into we adopt a 4-part test. And the bottom line, overarching concern is whether the adverse inference is trustworthy under all the circumstances. So play this out. This is probably this goes right directly to my question. He gets up to stand. The question is, did the plaintiff know whether or not he was being reported at the time? Which is the central question, I think, that he intends to fit on. And he says, I think that at that point, it seems to be the adverse inference is to the plaintiff.
Right, and we would just...
There's no evidence anywhere else that he knew anything that he did not know he was being reported. The only thing that's contrary is Mr. Clinton's radio show
Well, that's not entirely true. I'm trying to think about what I can talk about. Mr. Clem's version of events is like a schoolyard seesaw. At one point, he comes on the air and says repeatedly on his own show and on the Howard Stern show that Mr. Balea was aware of the recording, he was aware of the tape, he was aware of the dissemination. They then settle the case. In that settlement agreement, as part of the terms of it, he says, I am going to say that you had no role in disseminating the tape, that you did have no knowledge of the taping. I'm not going to disparage you. I'm going to cooperate in pursuit of Gawker. I'm also not going to disclose any information about you concerning your personal life or sexual life. And the case is dismissed without prejudice against him for $5,000. Because it's without prejudice, that guillotine hanging over his head if he doesn't comply with all of these things. He then goes and he issues a public apology saying the opposite, so we told back another way. He then goes on Howard Stern later and flips back the other way. He then shows up at the deposition where Mr. Balea and counsel are there, and he comes back the other way. In the interim, we know that he said other things an opposite way. Whether it's trustworthy or not, we would say that given the circumstances in the case, Mr. Balea has control over him, which is exactly the situation that it was in Kakina, and that the person in Kakina there was control over, had continued loyalty to, and he had agreed to cooperate during the internal investigation. And the court said that's sufficient. Just to be clear, we're not asking for an adverse inference here, but we do think that we have a right to question Mr. Clem about the nature of their relationship, the nature of the relationship between the plaintiff and Ms. Clem, who for her part, there's only 3 parties in this. The plaintiff, who we've already seen testify, we've seen like a hair of Ms. Clem's testimony, we'll see more, and part of what she says corroborates the plaintiff's story, but she also testifies that the plaintiff is sitting at the table and she's intimidated testifying in front of him. I'm not sure what inferences to draw from any of this, but the jury has a right to test the credibility of all 3 of these people, who are the only ones who know what's going on. And then, frankly, we'd be extremely prejudiced to not have them here for all of these people.
But go back to the initial start of my question was, when we spoke about this morning, I recognize the fact that you potentially should not have to give up your strategy, questions,
right
part of it. However, how is the court supposed to make those, go back to my question just a minute ago, how is the court supposed to make those determinations unless you're proffering it ahead of time? The determinations that are outlined, not necessarily the 4-part test, but all the other parts of it that the court is supposed to consider in their discretion under Kakina.
Now, in Kakina, as I recall, and I may be mistaken, as I'm sure Mr. Kirkell will remind me if I am, but I think the district court actually initially said that they would not find this testimony trustworthy, and then later after they said, oh, it turned out it was after the person who got it.
Right, so I think that's pretty much what I'm saying.
Right, and to be perfectly candid, I have no idea whether Mr. Clem will be trustworthy. I don't know that anybody in the room would know that Mr. Clem is trustworthy on any of these stories. We don't know. But the only way to evaluate that is in the context of what he actually says. What we intend to ask him about is, 1, the nature of his relationship outside the context of this with the plaintiff. 2, the nature of his wife's, or his ex-wife's relationship with the plaintiff, which doesn't get to the fair. And 3, there are numerous statements by the plaintiff and by Mr. Clem unrelated to this topic, but related to other issues in the case that they made on the radio in another context that we should be permitted to ask them about. On things like, did the plaintiff know that he was being billed? Did he know that Mr. Clem burned the DVD? Did he know that he held the DVD? Did he know what Mr. Clem did with the DVD? I expect that he will take the Fifth, and we do not intend to belabor that point, but we should be permitted to ask a series of questions in which he takes the Fifth on.
In which case?
In which he does take the Fifth on those points. But, I mean, that's what we're planning to do. I mean, I don't want to give away the farm. I'm happy to make some sort of profit, Your Honor, but I don't want to disclose to the plaintiff's counsel or the Mr. Clem's counsel that it precisely answers the question.
And I appreciate that. I guess the question for the court is the responses. It seems to me that Kakina tells me I need to hear the responses.
or whether he'll invoke, actually.
In order to make those kinds of threshold issues, I mean, it's nice when there's an appellate court that can review it all later on. I'd like to try to get it right the first time around. So I don't know how to square that necessarily, though, with your right to determine your case however you want.
I don't
Without telling me to review.
No, I appreciate that, and I would like to put on the case that we want. But I think that in Coquina, the way that I understand these four factors is a prospective look, right? I mean, the nature of the relationship between the witness and the party. We know that these fellows have been long-time, intimate friends. Second, the degree of control of the non-party. The settlement agreement gives them a leash around Mr. Clem's neck to say what they want him. The compatibility and the interests of the party directly aligned. Despite Mr. Clem saying he could both fit in these four walls, apparently on the airwaves around here, he's been going on at some length about the testimony and his own personal spin on it. And then fourth, the role of the non-party and the witness in the litigation. He's the central person in the case, next to Mr. Vallejo. And I just prospectively going in with those four factors, that's what the court is supposed to look at.
And the ultimate trustworthiness, which seems to be the overall, I mean, that's at the beginning of, it's the bookends. It's the beginning part of the test, it's the end part of the test, is the overall trustworthiness, and that's the...
Well, I take your point, Your Honor, and I mean, we are in a bit of a bind because Mr. Clem is a pathological, untrustworthy person.
I thought he was going to use the L word.
And from our position, we believe that the plaintiff, in all candor, has a reputation for dishonesty as well.
That's your position.
That is our
And
position.
he's a party. He's totally different.
You're right. But we're now stuck in a position saying, well, the plaintiff and his best friend, side by side, bosom buddies, he's a former best friend, are both, in our view, dishonest. There's no way that we're going to get trustworthy information, we believe, from either, but we should be able to allow the jury to come and hear what Mr. Clem has to say about the nature of their relationship, the nature of his ex-wife's relationship with the plaintiff, the things that he and plaintiff discussed on the radio, and then take the fifth of these limited number of questions.
Judge, I don't know where he's... If
And
he's
now,
done...
Mr. Turkel and then Mr. O'Brien gets to close.
Judge, first of all, starting at Coquina only applies if they're seeking an inference. I mean, it says that at the beginning of Headnote 9. It says, mindful of this potential for inaccuracy and unfairness, other circuits have held that the admissibility of a non-party's invocation of the Fifth Amendment privilege against self-incrimination and the concomitant drawing of adverse inferences should be considered on a case-by-case basis. The whole premise of the Coquina factors is whether you're going to allow a jury to draw the inference. Because as all the Florida courts have said, it's dangerous when you put a witness up there who's a third party and they're invoking. I understand that there are citations to older federal cases in favor and Guzman. They're still the law in Florida. And you can't really right now say they're not binding precedent just because the 11th Circuit, which, by the way, was not relied on. It's not a Fifth Circuit case that relied on. It's a First Circuit case, actually. I think U.S. v. Johnson is the one they cite. Has come out and it fits squarely into this strategic mess they've created. I take issue with this idea that the settlement was restricted to $5,000. There were copyrights in there and other things. Equally speaking, Your Honor, there is only one statement under oath at issue here, and that's the deposition. The radio banter he discussed, the radio apology, and the radio banter before the apology, were both available to preserve their rights at the deposition and were retracted under oath. And so they had a chance to confront the witness from the standpoint of this overall pitch that they've been deprived fairness. They confronted it. And honestly, from an evidentiary perspective, if you're looking for trustworthiness, the only piece of evidence that becomes admissible under 804 once he's available is the deposition, which is the only sworn statement we have. Now, going back to the overarching unreliability of it, I think Mr. Berry somewhat made my point. He just called the witness who he seeks to invoke and put in this position a pathological, untrustworthy person. I think we all know what he meant. The truth of the matter is, Judge, you have 3 or 4 statements at or around the time of this stuff happening. You have the demo in which all of them except one, which I won't mention on the open record, was not available at the time. You have a subsequent one, the TPD report, that is in public record, in which it lines up with the deposition testimony and the only statement under oath we have. And so you go back to where does that leave us? And I think it leaves us in two places. One, I think the court's still squarely bound by Guzman, and I just don't think there's any way we can make an argument that you should go to federal law, particularly when they've conceded that the factors they want to apply, they've conceded they don't want an inference when the factors that they want to apply only relate to the giving of the inference. And secondly, Judge, when you go to the overarching unfairness, the truth of the matter is, maybe Mr. Berry's right. Maybe the argument he made does make sense in the sense that this is also untrustworthy, that you really can't put your imprimatur on it and get into this drill of the witness invoking when there's so many statements out there. All of it subject to the fact that we are talking about a Fifth Amendment right, which, I'm sure Mr. O'Brien and his client is extremely important. So that's kind of where we come down on this, Judge. I just don't think he can invoke on the stand at all. And then I think if they're going to call him, and Judge, I don't think you get it both ways. You can't come into the court and say, we don't want to proffer these questions on this constitutional right for strategic reasons. Trust this, Judge. It'll be okay. Because you have all the cases we cited that deal with whether they're using it as subterfuge to set up some other kind of impeachment. And we can't bet that argument if we don't know. So.
Judge, I'll gladly cede my time to Mr. Berry if he would like to.
Mr. Berry, do you have a few things you want to say?
I appreciate what Mr. O'Brien said. I might want to hear from him first, and then I may give you the board.
Judge, as I said at the start of this hearing, took place this morning via sidebar, Mr. Clem and I have no dog in this fight. However, when it comes to my purpose for being here, it's to protect Mr. Clem's constitutional rights, and I intend to do so. With respect to the issue of certain areas that I've covered, both in my pleading and sidebar, I think that Guzman controls. The defendant is prohibited from asking these questions in front of the jury. In terms of any other innocuous question, something that does not involve a constitutional right, I attempted to find out what those questions were and try to avoid this to begin with, and I was unsuccessful. So here we are, and I still don't know what those topics are. I fear that we're going to create an even larger spectacle where I'm either sitting right there or, even worse, up there, whispering to my client or nodding to my client, no, yes, and it's going to turn into something that's unnecessary when we could simply do this outside the presence of a jury if this court is going to rule that this is a coquina factor matter versus a Guzman matter. I happen to agree with Mr. Turkel, not because I'm on the side of the plaintiff, simply because I believe that Guzman controls, and I think this is the way the court should rule. If the court has any other questions for me, I'd be glad to answer them.
Well, I guess I would just end where to begin with Mr. O'Brien began. Mr. Clem does have a dog in this fight, and his name is Mr. Belay, and the settlement agreement that he's bound to comply with. And I take what Mr. O'Brien says about the Fifth Amendment. The fact of the matter is that Mr. Clem promised to cooperate with Mr. Belay to go after Gawker. And on the radio, he's been saying that he hopes that Mr. Belay collects substantial money from us. This whole ruse, we don't know what's real and what's fake here. And when Mr. Turkel says the only statements that he made under oath were at his deposition, as Your Honor knows, that's right as only as far as it goes about what statements here were under circumstances that should have been trustworthy. In that deposition, there are numerous statements that are demonstrably false that Mr. Clem made. And so to point to the one statement that Mr. Belay didn't know was being filmed as the gospel at this point makes no sense. There's numerous other statements he made about all sorts of circumstances involving the case at issue, or the case at issue here, that are demonstrably false. And so in that deposition, he didn't say those things. I have no idea that they're true. And I would suggest that given the circumstances surrounding that at the deposition, they were false. The bottom line for us is that this whole situation is incredibly prejudicial. The plaintiff has decided to go after us while settling with the one person who apparently knows the truth. And now that person is not going to come in and testify as to those facts. And we cited cases in our paper in saying that in parallel circumstances, courts dismiss these kinds of cases. If you can't get at the truth because of some implication of the privilege, you can't proceed. There's three people who know. Mr. Vallejo, Ms. Cole, who will tell you the story that she's going to tell you when we play her deposition, but will also say, I'm intimidated by this man sitting here. And then Mr. Clem, who's never going to hear this story.
So,
Just one point, Judge? Okay.
so, Mr. Beer, I'll write this to you. So, I am going to grant the motion to quash based on the untrustworthiness of this. However, I think that you should be entitled to proffer that testimony for the record outside the presence of the jury. Bring Mr. Clement and ask him your questions so that you have that reserved one way or the other. But definitely outside the presence of the jury.
So the idea would be to preserve his testimony, but none of that would ever see the light of day. As far as this trial is concerned.
Judge,
I think that you have a right to preserve your record. No one knows what he would say one way or the other to your question. That sort of goes back to my point that I started with in the beginning. So unless I heard it, how would I know? There's all those other factors that I'm supposed to consider in addition to the foreclosure.
Your Honor, at that point, if we were to do it, I think this would be something akin to a videotape deposition.
Well, I would see in the video.
But I mean, at that point, once we have a record of what he says, would there be a possibility of playing that to the jury?
is that, if I may for clarification, is that assuming he doesn't vote?
I don't know what questions they intend to ask. I don't know what kind of responses he intends to give. So, but at that point in time, it would at least be preserved for somebody in court to say, yeah, Daniel did something wrong, or we're ready for Daniel.
I think you have to do that, but the proffer. But the other point, Judge, and it was one point you didn't let me make at the end, was once he invokes, he is unavailable. The deposition at which they had confrontation rights becomes admissible under 804. They're not deprived of the right to designate. They had cross-examination rights there. They took the deposition. Equally speaking, the comment they made about Heather Cole, the party stipulated she'd appear by demo. So, it's not like they were deprived of rights at the depot for the, quote, demonstrably false statements that they were confronting at the time.
Well, I think there were some aspects.
One
Aspect that became a big one for the defense.
It
was not available at the time of his deposition.
Nor was the TPD report that subsequently came out. There are other rules that may deal with that. And we can get to that if they choose to publish.
And I guess my only thought is, putting it on the bottom of page 5, justice and some other will have to prevail on that one.
I have to see what you mean, Your Honor. And just on one point with respect to
I don't know how to zip it sometimes.
footnote.
One page.
I'll take a look at that. I apologize, Your Honor. The one point to what Mr. Turkel said. We will make a decision, I guess, about whether to play Mr. Clem's deposition testimony. With respect to the confrontation, at the time that he was deposed, he was an available witness that would give me the discovery deposition. As I just mentioned, he made numerous false statements, which he did
We're on the way into the topic, right?
No, but I mean,
It
we're
doesn't
this.
necessarily to the motion to quash.
It doesn't, but it does get to this point of how we can do, how we're going to handle this prejudice and whether he's unavailable and can use that deposition. It's a game. It is a great game at this point.
But I think we have to then drop back and decide how you want to proceed, and then you'll give me something to say how you want to proceed. And
give you some kind of rule.
Thank you.
Right.
Yeah, no, that's exactly
I'm
right.
not
I did
telling you
wonder.
what's the next step. I'm just ruling simply on this one as, primarily on trustworthiness aspect of it.
Thank you.
Okay. So, but I think that, and you're talking with Mr. O'Brien, you all need to, if you intend to, if you want to go down that other path outside the presence of the jury, and the defense needs to coordinate with that meeting.
Right. Well, we'll need to get together another trial days over the next several days to see what would be possible.
Yeah, I think that's what's left, is they have to make a decision about proffer, and then we have to logistically discuss when we can do it.
And Mr. O'Brien can talk to his client about footnote 1 and file page 5 of the defendant's
Okay. Are we going to go back in, or they want a short recess to deal with this?
Okay.
Yeah, just to be clear, on that point, we don't need to re-subpoena Mr. Frank. I mean, he's under subpoena to come to whatever it is, sort of separate proffer will be.
Yes. That would, if the defense wants to pursue that, yes, we don't need to re-subpoena him.
Yeah,
So the subpoena is really for, or the ruling is primarily for testifying for the.
I think would it be fair to say
Mr. O'Brien and Tom.
the trial subpoena is quashed, but he has been ordered with his counsel here to appear for a proffer. Is that fair?
That would be a fair statement.
That makes
Mr. Berry,
sense.
did you hear that? So he said that the trial subpoena would be quashed, but to appear before with his counsel for the proffer would be civil.
Yeah.
Okay,
He's otherwise ordered by the court to make himself available for proffer.
Yes.
Okay.
Mr.
Understood.
O'Brien, you understand? Thank you, Mr. O'Brien, for coming back.
Any excuse, Your Honor?
Thank you. Okay. Anyone need to bring the board with you? Mr. O'Leary?
He's not in here.
Oh, okay.
We kept them in a secure location.
Okay. So why don't we take just a brief break, bring Mr. O'Leary back and bring the jury.
Thank you.
Thank you.